Hi, welcome back to Space Thoughts. Today, I'm going to talk about this idea of due regard and potentially harmful interference. And this is part of Article 9. It's the only place in the Outer Space Treaty that these two terms actually appear. And I'm going to talk to you about it just because, one, I do a lot of thinking about Article 9. And in fact, I'm getting ready to probably within the next few weeks start writing a special issue of my briefing letter on this idea of Article 9, in particular the legal requirement for reporting requirement and the right to consultation that I'll talk about in a little bit here. But I'm really taking this up more or less because last week, Monday and Tuesday, the Air Force Academy hosted the second annual U.S. Spacecom Legal Conference, and I attended it virtually. And it was an excellent conference. And I want to just, shout out to the Air Force Academy, U.S. Spacecom, everybody else, and all those University of Nebraska who have sponsored lunch, as well as the Ole Miss, University of Mississippi, who actually sponsored part of the uh, conference as well. It was really an excellent conference, and I encourage you. The videos are up on YouTube. I'll leave a link in the description so you can actually go look at those. But there were two panels in particular that I want to talk about today. One on the first day dealt with this idea of due regard in Article 9, and on the second day, there was a panel that talked about harmful interference, or as the words in Article 9 is, potentially harmful interference. And it was an interesting discussion, and a lot of it was, how do we define this? What does it mean? How do we define it? And that was really what in both cases. In other words, what constitutes due regard? What constitutes potentially harmful interference? And I mean, I've had my opinions. I opine that maybe perhaps this is something you need a legal test for as opposed to a legal definition. And I got some interesting answers from that. If you go watch the video on it, you can see the response to it. I'm not going to go through it on here. But what I will, I just after the conference, I really started thinking about these two principles and really looked hard at them. And I think one of the things we have to understand is, like I said before, these two terms, or these two principles, or whatever you want to call them, they only appear in Article 9 of the Outer Space Treaty. So I think what we're going to do is we're going to look at Article 9 of the Outer Space Treaty. Now, I laid it out like this. If you look at Article 9 in the actual treaty text, it's basically one paragraph with four long sentences. And I decided to break it up just for sake of ease, for analysis sake. And I think honestly, if I had helped draft a treaty, which obviously I didn't, I wasn't even born then, I would have suggested maybe breaking it up a little bit. But people do, drafters do this for a reason. They're intense, and you see this sometimes in contracts law. This is, quote, the proverbial fine print in a sense, in my opinion. But anyways, enough of that. Article 9 is, in my opinion, one of those provisions of the Outer Space Treaty that is people like to avoid at worst, and at best they like to dance around it, because it really is it is controversial in a lot of respects, because it to some respect it's really never been invoked, and it's so innocuous that there is nothing, there is things that that people just don't want to talk, just people don't want to really nail down. In other words, this is very vague and vacuous as to what, how this thing is applied in some respects. But just to look at it, and the idea, we have these terms with due regard and the term potentially harmful interference. And unfortunately, I think, what happened with the conference is they treated these two kind of separately. They had one panel on due regard and one on potentially harmful interference. And I think, honestly, they should have been taken together, because the two are not exclusive. They're both mutual. They're both together. So let's look at this first one with due regard. So in the exploration use of outer space, including the moon and other celestial bodies, state parties to the treaty shall be guided by the principle of cooperation and mutual assistance, and shall conduct all their activities in outer space, including the moon and other celestial bodies, with due regard to the corresponding interests of all the other state parties to the treaty. All right. So what does due regard mean? And trust me, when we spent about at least an hour on this on the panel the panel spent at least an hour on this, looking at this and talking about what this term due regard means. Well, I got kind of sucked into this too, because my idea, I opined that this is more of a legal test than a legal definition. But I really don't think this is, in my opinion, this idea of due regard isn't really have a legal definition. Understand this first sentence in Article 9, this idea of due regard, sets up the rest of Article 9. And actually what it does, it basically says, okay, we have this principle due regard, and sentences 2, 3, and 4 basically implement this idea of due regard. So in other words, due regard, in my opinion, is a principle. It doesn't have a definition. It doesn't have a legal test or a legal meaning. It's basically a principle, and the principles or the meaning or the way this idea of due regard is supposed to be implemented is laid out in the rest of the sentences. So let's look at the first sentence. State parties to the treaty shall pursue studies of outer space, including the moon and other celestial bodies, and conduct exploration of them so as to avoid their harmful contamination and also adverse changes in the environment of the Earth resulting from the introduction of extraterrestrial matter, and where necessary shall adopt appropriate measures for this purpose. This is the planetary protection guideline of due regard. In other words, we're basically offering due regard for scientists on planets or the moon or other celestial bodies or in outer space itself. We don't want to contaminate the environment for the scientists, so they can actually go there and do the science. And trust me, this is what it means. This is what it means. There really isn't an overall moral overreaching. We got to preserve the environment, the outer space environment, as much as we got to preserve the outer space environment for science. So and that's kind of fills in with the basic tenor of the Outer Space Treaty being, very heavily weighted in the idea of science exploration, what have you. But it also has a mandate of, we got to make sure if we bring back anything from Earth, but we don't contaminate the biosphere. So in other words, if we bring back a sample from a comet or an asteroid, there got to be appropriate protocols put in place. Well, for example, Apollo 11, when the astronauts came back, they were isolated for a time to make sure they didn't bring back any pathogens that may have been on the moon, that may have survived on the moon all those millennia and just been picked up by them. And that was basically in reference to this whole idea of not contaminating the biosphere. Even though the Outer Space Treaty was only like a couple, just very, very putting it into force at that time. But that's the idea. And basically this is implemented by countries domestically in their domestic laws or the domestic procedures. NASA has planetary protection protocols. ESA has planetary protection protocols, and all that comes from this first implementing sentence of Article 9. That's fine. And everybody knows about this. And when people talk about Article 9, this is usually what people talk about. What people don't like to talk about too much is the next two implementing sentences of due regard here. And the first one is basically what they call the second legal duty. The first legal duty being planetary protection, both for extraterrestrial and the Earth. The second one is about this idea of activities that would potentially would cause potentially harmful interference. So what is that? Well, we don't know. There is no definition for that. Nobody has defined it, and it probably won't be a good definition for it. Is there a legal test for it? Maybe. I don't know. There could be a policy. There could be a policy statement on what potentially harmful interference means for each state. But chances are they keep that in reserve and don't actually put that out there. So again, this is another vacuous term, but this is actually implements due regard. So in other words, instead of due regard being this defined term, this idea of potentially harmful interference actually implements this term, is one of the implementing measures of this term. So again, there really is no solid definition for it. But again, this is a very this sentence, this implementing guideline, or this implementing clause here, basically is very controversial because it requires a state to consult prior to an activity that may cause potentially harmful interference. And the whole idea is where is that line? Where is that line where a state has to go in and actually consult on another state with this idea that an activity may potentially cause potentially harmful interference? Nobody knows, because this consultation requirement has not been introduced, has not been activated or basically tried yet. It's something that's been sitting there and sitting around in basically the vacuum right now. Let's talk about ASAT tests just for a little bit. During the Cold War, both the U.S. and the Soviets, we did some ASAT tests. Soviets are mostly co-orbital. U.S. had one notable declassified test. It was against from an air-launched ASAT against a Sol-1 satellite, and such. So, and then the Chinese in 2007 did their direct ASAT test, and India did a direct ASAT test in 2019, and you had all those three, but in no term, in none of these instances did either the U.S., China, or the Soviet Union or India invoke this mandatory consultation requirement in Article 9. And why is that? Well, I'm not gonna get too much into this because I'm actually writing for my briefing letter. Again, I think I mentioned that earlier, this idea of Article 9. I don't think national security activities apply to it. And I think that's more, and it's a matter of state practice, but I think it's also a matter of state practice actually going into customary international law. So as far as national security activities go, I don't believe that there is any, I don't believe that Article 9 actually applies to them because of activities by the US, Soviets, and China, what have you. In fact, if you go back to the 2007 test, there was a very interesting comment by the Chinese after some of the uproar started spilling over, is that, well, we did this because basically we were consistent with international law, and I think they were right. I think they were right in that. But again, if you're subscribed to my briefing letter, I'll be talking about this and more, hopefully getting up by sometime, maybe the second or third week of next month. At the latest. But understand, this thing has never been invoked before. But this whole idea is, this sentence is one of the things that basically implements the idea of due regard. Getting back to the thing that due regard is not a defined term or a term that can be had through a legal test. It's basically due regard is dependent on these three sentences here in the Outer Space Treaty, these two legal obligations and this one legal right. The third sentence invokes it basically talks about the one legal right, and that's the duty or the right of a state to request a consultation of another state that is doing these actual tests or doing these activities that it thinks will be potentially harmful. In other words, it says, hey, we think you're going to be doing something. Your experiment is going to cause potentially harmful interference, and we want to actually go out, reach out, and can you tell us about it? Can you tell us more about this so we can be prepared, or at least put our minds at ease? This is going to interfere with our satellites or our astronauts, or what have you. So that's what this one's about. And this was invoked, or tried to invoke, once after the Chinese ASAT test. The Japanese actually tried to invoke this afterwards, demanding a consultation on this. But I don't think it would. I don't think it really took, because the idea is here in the sentence is would cause potentially harmful activities. In other words, or which has a reason to believe that activity or experiment planned by another state party in outer space, including the moon and other celestial bodies, would cause potentially harmful interference. In other words, this has got to be taken proactively or preemptively. You got to invoke this right beforehand. Again, I don't think I don't think that one instance where it was invoked by name, that the whole idea of this Article 9 consultation right was actually invoked. So this is what kind of makes Article 9, kind of a gray area, a very, very, very gray area in the Outer Space Treaty that really has yet to be tested in any meaningful way. But understand, these two legal rights, these two legal duties and this one legal right in Article 9 all come down to this, all implement this idea of due regard. In other words, due regard is, in terms of the Outer Space Treaty, is found in these three sentences and in these two legal duties and this one legal right. So in other words, due regard doesn't really have a definition. The trigger for due regard is that this idea of potentially harmful interference or this idea of planetary protection. So really, otherwise, I think trying to fill in the gaps and trying to get a legal definition for what due regard is, I don't think you're going to do it. Will we come up will there be a point where we come up with this idea of what potentially harmful interference means with the Outer Space Treaty? I don't think so. I think this is something that's going to be danced around for a long time. Now, with the Artemis Accords, maybe in the future when there's activities on the moons, the members of the Artemis Accords might come back and revisit this idea of, you know, due regard and in terms of Article 9. But they might try to, but my guess is they will do it in a way that actually glosses over this idea of, you know, potentially harmful interference found in the last two sentences of Article 9 of the Outer Space Treaty. Now, interestingly, I talked about in a couple videos back about this idea of PRC filing this complaint with the UN Secretary General about the Starlink satellites and the alleged almost conjunctions, collisions with its space station. And the idea is they used, I mentioned in that they used Article 5, which was totally inappropriate. And my thoughts on this is that maybe they were trying to conflate this idea of potentially harmful interference or due regard with Article 5 in a sense. In other words, they really didn't want to trip this idea of this Article 9 idea of due regard. So I think they may try to use Article 5 and some of the terminology in there to actually mean potential, you know, due regard and potentially harmful interference without actually triggering Article 9. I think Article 9 is, you know, especially these last two sentences are very tricky for states. They don't want to actually invoke them unless they really have to, because once you do that, I think you start the ball rolling and open up problems for, you know, potential problems down the road politically. I mean, this could be actually used as a lawfare weapon, in my opinion. So I think honestly, in the long run, even in the long run, this idea, we're always going to do the planetary protection thing. We've all, you know, that's pretty consistent and pretty established. But I think these last two sentences, this last legal duty and this legal right, they're going to fade away. But what I want you to get out of this was, you know, the idea of due regard and potentially harmful interference, they really can't be separated because one, you know, this idea of due regard is dependent on these implementing factors or these implementing duties and rights under Article 9. And I think as such, whenever you got to talk about due regard and potentially harmful interference, you really got to talk about them together and vice versa. Again, tricky stuff, innocuous stuff. I know a lot of these ideas that this will never, in my opinion, won't ever be implemented are controversial. Some heads will explode. It's definitely, but definitely, you know, this will be a topic for academic and scholarship writing for a long time, and such. Interestingly, I know one NGO during the after the Russian ASAT demonstration back in November, basically asserted that, you know, they violated the Outer Space Treaty because they didn't trigger this consultation mechanism here in Article 9. In other words, they didn't consult with everybody before they did this demonstration. Again, I think that's I don't think that's a non-starter because I don't think, again, in a generality, I don't think Article 9 applies to national security activities as a whole. So again, that's just a rough idea on due regard and potentially harmful interference as such. And again, this is tricky stuff. And just understand the Outer Space Treaty wasn't really designed to be specific, and most treaties for that matter are seldom very, very specific because states do have interests. They want enough wiggle room so that they can exercise their interest and give varying interpretations and everything. So again, it's the world we live in right now, and it is what it is. I mean, it's not a matter of this is a bad thing or it's a good thing. It's just the way it is right now, and we got to work with it the way we are. Again, I think, and honestly, I think more as we go into outer space activities, we'll be relying more on customary international law. Because I think treaties are a passe thing just because of things like this, because of how can you say, very vacuous ideas or principles like this. So anyways, that's all I have for this one, and I'll talk to you next time.